Good morning, everybody, and welcome to the webinar this morning. My name is Nicky Hardwick, and I'm going to be presenting. Just by a show of hands before we continue, can I just get a thumbs up that you can see the presentation and that you can hear me? If we just get a couple of, thank you, Stephen. All righty, thanks, everybody. Okay, so what we're going to be talking about today, and I'm going to try and get this done in an hour. The basic conditions is with quite a lot of stuff, but I'm going to try and cover sort of the main things that you guys would need to know. And then if you need things in more detail, which I'll deal with at the time, but things like going more into leave, things like overtime, then I would recommend that you possibly join one of the other webinars that we do, which go into more detail on leave and calculation of overtime. So the purpose of the webinar today is really to give a more in-depth overview of the things that employers should know regarding the basic conditions of Employment Act. Okay, so what I'm going to start with first is to just understand what is actually the purpose of the basic conditions. Okay, so without going into, all the handwriting and, looking at what it says, but in essence, what the basic conditions is to provide sort of guidelines, for employers in terms of what the basic or the minimum guidelines or the minimum requirements to give to employees that work within organizations. The idea was to promote fair treatment. So in other words, is to look at what is the maximum number of ordinary hours that a person can work? How much leave should a person get? If the person is leaving, how much notice should they or shouldn't they get? And then obviously to look at managing that compliance. So I'm not entirely sure, but a number of you may have at some point been audited by Department of Labour relating to things for the basic conditions. And so the basic conditions will be looking at things like minimum wage. It will be looking at things like pay slips, what is on your pay slip, as I've said before, your leave, etc. So in essence, that's what the basic conditions is. Now, the basic conditions is not the only piece of legislation. Sorry, just to go back a second, what the basic conditions will also cover, which I haven't necessarily covered in here, is if you fail to comply, what are the consequences to you as an organization? So are there fines? What will happen to you as an organization if you do not comply? What are the rights of the labor inspectors? So if you fail to comply, what process they should follow, and that kind of thing. There are also things within the basic conditions which I'm not specifically covering here, but for example, what is the age at which people can start to work? So, can people work at 8 years old? Can they not work at 8 years old? So it will look at those kinds of things as well. Okay. So what we're going to start off first is basically we look at the basic conditions, and then just very broadly is just to go into the other types of legislation. Remembering that in South Africa, we got a number of different legislations that will govern the employment of a person. So obviously the Constitution sits at the top and sort of feeds into everything else. But we have the Labour Relations Act. So how I like to describe it very hopefully easily to employers as well as to employees is if you look at your basic conditions, that would be the basis on which we, for argument's sake, would have our contract of employment. So it's where we would decide as we're getting into inverted commas a marriage, what are the basic things that we're going to agree to comply with. So it's still at the point that we love each other, that we're all happy, and that things are great. The Labour Relations Act, on the other hand, is at the point that we begin to fight. So the Labour Relations Act will deal with things, not only these things, but it will deal with things like what happens if you're looking at dismissing someone. What is the process that you need to follow? It will also look at things like unions as well as bargaining councils. And so the Labour Relations Act almost defines for you the rules of the fight. So your basic conditions is the minimum conditions under which I can employ a person. And then your Labour Relations Act is the rules that we need to, both as an employer as well as employee, to decide how we're going to fight. Then you have the Employment Equity Act, which I'm not going to go into great detail, but the Employment Equity Act relates to the fairness in terms of discrimination, as well as the compliance for designated employers. Occupational health and safety, which will deal with, your obviously safety in the workplace. Your Skills Development Act, which is your training. UIF, and then the contributions, which is what do we pay for people who are working, so the 1%, etc. Your compensation, so the COIDA and what you need to pay to obviously protect people in the workplace, and then finally our national minimum wage. Okay, so just to be clear, the basic conditions feeds into a lot of these other acts and actually works in conjunction. The main objective of today is to discuss the basic conditions. So when we look at the various different things and the various different acts, I want to be clear that sometimes that there is a different definition for certain things. So when we look at the basic conditions, and I'm going to go through now what the definition of an employee is, that might be different to when we, for example, look at an employee, for interpretation note 17, an employee versus an independent contractor. So when you're applying the legislation, just be careful of applying one rule for a certain thing. For example, when we're looking at the definitions, you need to consider, the context in which you're working. Okay. Also understand that there is a national minimum wage, which applies to every single employee within the country. So you can have a bargaining council or a union agreement that has a different agreement in that space. But if you're not covered by a bargaining council or a sectoral determination, or have a union that has negotiated wages, then every single employer is covered by national minimum wage. Now, the national minimum wage is a set amount, and it's an hourly rate, or if you're working 45 hours a week or the equivalent in a month, you are required to pay, and I don't know the exact maths, but I think it's 4,700 Rand, which you are required to pay as a minimum. So the basic conditions does refer to the national minimum wage. It also actually refers to the threshold, which come from the UIF Act. And so there's various different things that you would need to consider. Okay, so first things first, what we're going to look at is what the definition is of an employee. Okay, so in terms of the definition, and I'm going to go into section, I think it's 83 as well, but the definition as defined by the basic conditions is that it's any person excluding an independent contractor, okay, who works for another person or for the state and who receives or is entitled to receive any remuneration, or any other person who in any manner assists in carrying on or conducting the business of an employer. Okay. Now, taking into account this little word, these words over here, which is your independent contractor. Now, interpretation note 17, which actually comes from SARS, there is a test there to determine whether a person is an employee or an independent contractor. Remembering that the fact that you just call them an independent contractor doesn't make them so. You have to conduct the test and you have to determine, and that's specifically to determine whether or not should you be paying, the person's PAYE. Are they a person, excuse me, are they a person that should be covered by your workman's compensation? Do you have to pay UIF for them? The fact that you have an agreement that says that they're an independent contractor does not make them so. Okay, I am going to go into also section, I think it's 83A, but I'll get to the next slide, which also then has a test, much like your interpretation note 17, which will then give you more information in terms of whether the person is an employee. Remembering that in terms of the sections of the BCEA, there are many people, or at least many sections, where a person who works for you for less than 24 hours a month are not included in that. So you're not required to give a contract. Remembering it's 24 hours in a month. So that would be probably about 4 days of the month of less than 8 hours. So if somebody is working for you for less than that, then they're not covered by various provisions of the basic conditions. Okay, so if we then have a look as to the presumption as to who an employee is. Okay, now this is section 83A of the basic conditions. Basically what it says is that if one or more of the following is true, the person is presumed until proven otherwise to be an employee of the employer. So I haven't included all of them. I've just included the main ones that would probably apply to most employers. But the one is the person is under your control and direction. And again, as I said before, this is very closely linked to Interpretation Note 17. And the idea here is that what they're trying to establish is to go, should you as the employer have more of a responsibility towards this person that is working for you? Remembering, if a person is an independent contractor, they are in essence an external party. So if you no longer want to do work with them, for example, a plumber who comes to your house as and when, you can decide you don't want to use that plumber anymore, and then you just use another one. With an employee, there are certain provisions that give them protection. Like I said before, within the Labour Relations Act, if you need to dismiss a person, there's a certain thing that you need to do. You cannot just dismiss a person. You need to have fair and justifiable reason. And so this test over here is basically trying to ensure that you as the employer are held accountable, rather than just having an agreement that says that the person is not an employee. Okay, so as I said before, it's a person who's under your control and direction, and it's not all of these factors. It is one or the other, or at least one. They are considered to be an employee until proven otherwise. The hours of work are determined by you. They work an average of 40 hours over the last 3 months, so it's 40 hours per month. The person is economically dependent on you. You provide them with their tools or work equipment, and the person only works for you. So when we're looking at anything else that we go through, if you believe that the person is an employee, then many of these sections that we're going to go through will apply for you. Just one thing though is that in terms of an employee, this does not apply to people who earn over the threshold. So when we go through, I'm going to go through the threshold now. We're talking about the UIF threshold. So there are certain sections of the basic conditions that does not apply to a person earning over the threshold. I'm just going to jump ahead and then come back to the slide. All right. So the BCEA threshold changes generally every year. Excuse me. Currently, it is 254,371 Rand and 67 cents for the year. So if the person's annual remuneration exceeds that, there are certain sections that they are excluded from. So these are the sections here that they would be excluded. Now, what that really means is that, for argument's sake, if you had to look at the meal intervals, there's a requirement that you give a person at least 60 minutes off, which can be reduced to 30 minutes after 5 hours of work. If the person is earning over the threshold, there is no requirement to put that into the contract to say, I will give you 30 minutes off. Okay, there's also no requirement in terms of the ordinary hours of work, which is limiting it to 45 hours a week. There's also no requirement if the person is earning over the threshold to pay someone for overtime. So anything, just to, back up a little bit, is that in as much as there's no limit on, the 45 hours a week and the overtime, there is a provision that says it must still, any work that people do, even if they're over the limit, must obviously take into account health and safety of the person. Okay. So I will go into this in a little bit more detail, but just going back to here, is these provisions don't apply to a person earning over the threshold. All you would need to do is to go back to this definition to go, is the person an employee or they're not? You wouldn't have to apply this to somebody who's earning over the threshold. Okay. Just to say, though, is that in terms of defining who an employee is, very often what people will do is that they will try and manipulate, things so that they don't have to be tied into, for argument's sake, a contract to someone. So I will agree with someone, listen, let's call you an independent contractor. And what we will do is I'll pay you X amount of money. You sort out your own tax, you'll do everything that you need to do. everything goes fine, and then what happens is we then, I don't know, get into an argument with the person, or we don't want them anymore, or whatever the story may be. And at that point, the person then decides that it would actually be beneficial to them to be an employee, because if they're an employee, you can't just terminate their employment. Alternatively, we find out that they haven't actually paid across any of their tax, or God forbid, they get injured on duty. And we then find out that they're actually not an independent contractor. They should have been covered by you. And now you, as the employer, because you should have done the test to begin with, are now liable for any, injury, are liable for the tax that wasn't paid across, remembering the PAYE is your responsibility as the employer to pay across. And so that's not to say you can't have independent contractors. It's just really important that you apply the test and that you are clear that the person is in fact an independent contractor and not just an employee who is disguising themselves as one, or it's just a very convenient relationship to begin with. At the end of the day, the risk lies with you as the employer, if you choose to go down that road, because the employee, or in this case, independent contractor, could turn around at the end and claim that they were actually an independent contractor to begin with. Okay. Alrighty. Okay, so moving swiftly along. All right, so I've had this discussion with many employers over the years in terms of the requirement to do a contract of employment. So the basic conditions doesn't specifically call it a contract of employment. It actually, they refer to it as the written particulars of employment. I haven't specified every single thing that they've listed there, but there is a section there that specifies that on commencement of employment, as the employer, you are required to supply every single employee. I've said a contract of employment, but they've said written particulars of employment, which must include, so it's not optional, the name and address of the employer, the name and occupation of the employee, and they do specify there, or a list of the duties that the person is required to perform, the place or places of work, the date of employment, the hours of work, rate of pay and deductions, leave, their notice periods, and any documents that form part of that contract. Okay. So, it is quite important, if it isn't being done, that you put those things in writing. It doesn't have to be a 25-page document, but at the very least, it needs to be the minimum requirements as required by the Department of Labor. So obviously, if they, I see that there's a question, I'll get to it now. So if they do an audit, being Department of Labor, one of the things that they will ask is for your contract of employment. And they'll probably ask for one of a current employee. If they ask for one for a current employee, there's a good chance that they may actually interview that employee. So you need to make sure that the things that you, well, at the very least, your contracts of employment are in place and that they have the minimum requirements. Okay, let me just get to the questions quickly. All right, so if an employment person's contract says 8 to 4, so 8 hours a day, working Monday to Friday, 40 hours a week. Okay, hold on, they're below the threshold. Okay, so we'll talk about overtime, and we'll talk about hours of work shortly, and I'll get into how do we calculate that. So I'm going to park that question for now. Okay, so moving on to the next slide. As I said before, there's the BCEA threshold. Now, just to be clear, and in terms of the definitions, so there are two categories of staff that are excluded, excuse me, from certain provisions of the basic conditions. Taking into account, we can't treat people like slaves. We still need to make sure that they're safe and, health and safety, etc. But what we need to do is to apply the logic. And as I said, this does change. Well, it has of late in the last, I think, 3 years, this has changed. So the current threshold is 254,000 and some change. And if you are over that threshold, these things here do not apply to you. So what that means is you as the employer can decide how do you want to, to treat this. So for argument's sake, if somebody works overtime, do I pay you as one? Do I not pay you at all? Do I give you time off? there's no requirement for you to pay it at 1.5 or 2, etc. With exception of, so for argument's sake here, if you just have a look, so we got overtime payment for overtime over there, but public holidays, okay, only section 8.3 is excluded. So for those working over the threshold, you are still required to pay for time worked on a public holiday. Okay. If, however, we then go and have a look at senior managerial employees, there is a difference for senior managerial employees. So we've got over the threshold, and then we have senior managerial employees. Now, the senior managerial employees, there is a definition as given to you by the basic conditions. So you cannot just decide you're going to call someone this and then exclude them from everything. It is anybody who has the authority to hire, discipline, and dismiss an employee, as well as to represent the employer internally and externally. Now, if they meet that description, then they are excluded from a number of the sections within the basic conditions. So the overtime, the only real difference here between your above the threshold, is this element over here. So if we go back 1 second, you'll see here that over the threshold, they're only excluded. If we look here from 17.2 and 18.3. Whereas if you're over the threshold, you're excluded from the entire section of night work, as well as the entire section of public holidays. Okay. And in terms of the night work in that particular section, there are requirements that if you're working between 11 and 6, that I need to ensure that there is transport available. I need to ensure that you go for a medical. So there's a number of things that you as the employer are required to do. Also, with regards to public holidays, if I, as a senior managerial employee, work on a public holiday, I don't have to pay you at double time. Okay, so just remember this as we go forward. There are those two exclusions. There is also the exclusion of if a person is working for you for less than 24 hours a month, they are excluded from a number of these different sections. They don't have to have a contract. The ordinary hours don't apply. There's a number of things that they are excluded from. Please remember that it is less than 24 hours a month, not 24 hours a month. Okay. All righty. Okay. So and I'm still going to get to that question just now. So in terms of the regulation of working time, so we've got a section which refers to working time, and is actually the basis on which you also then look at your overtime. Please just remember that this is basic conditions. If you fall within a bargaining council, or you have a specific agreement with your union, or you have a sectoral determination that gives you slightly different hours, those will come above the basic conditions. Okay. Also remember that what you're not allowed to do as an employer, if the basic conditions, for argument's sake, says you can give people a minimum of 30 minutes for lunch, you are not allowed to, even by agreement, give less than 30 minutes. Okay, so you have to make sure that within your contractual agreement, that at the very minimum, you are providing employees with the basic minimum requirements of the basic conditions. So when we get to our notice period, I've had people that have said, well, look, if you're here for less than a month, the notice period is 24 hours. Both of us agree that's what we're going to do. Any person looking for a job is going to agree to 24 hours. It is not legal. You need to ensure that at the very minimum, you are doing what the basic conditions requires, which is not 24 hours. Okay. So just going back to the regulation of working time. So when we look at the basic conditions, what it says to you is that at a maximum, people are allowed to work a maximum of 45 hours a week. Okay. What it doesn't mean is that if you employ me to work a half day, so I have to work from 8 until 12. Okay, and from 8 until 12, you're basically paying me at rate 1. So for every hour, I'm going to give you, for argument's sake, 100 Rand. The fact that the basic condition says that your maximum normal hours can be 45 doesn't mean that you have the right as the employer to say, well, look, I employed you to work 20 hours a week. but I can make you work 45 hours, and only after 45 hours will I pay you overtime. Okay. This section over here is giving you the maximum that you can do. So you can be less, but you can't be more. So I can't make someone work 50 hours of normal time a week. Remembering that ordinary hours or normal time is paid at rate 1. So I employ you at 100 Rand an hour. And so for every hour that you work, I pay you 100 Rand. As soon as I exceed the normal time or the ordinary hours, I must now pay you overtime. So extra. So in essence, if we look at, and this kind of talks into the question before, is if your contract of employment or what is ordinarily required is that you working, I don't know, 40 hours a week. That is your ordinary hours of work. Okay. If I ordinarily work 40 hours a week, if you require me to work more than those 40 hours, anything over and above the 40 hours is now deemed to be overtime. Okay. So you need to make sure that your contract, you can have scenarios where you are actually paying people for a little bit extra. So I could, for argument's sake, say, I'm actually going to pay you every week for 40 hours a week. There might be some weeks that you, or most weeks that you don't need to work, overtime. But the nature of our business is you could have to work a little bit after. And so I almost bank a few hours. So you can do that, but what you can't do is just apply I'm going to make you work, if you're working 20 hours, I'm just going to make you work an extra 25 hours before I pay you overtime. That is not the intention. This is the maximum that you can ask anybody to work in a week of normal time. So i.e. what I pay 1 for 1. 1 hour of work equals 100 Rand or whatever the rate is. Okay. I'm also only allowed to work a maximum of 9 normal hours per day for 5 days per week. Or if I'm working, yes, just to clarify, if you're above the threshold, there is no overtime payment. And any overtime payment you would have to pay would be at your discretion. Okay, so you could actually be paying, 1 for 1, or I don't know, give you time off, or whatever it may be. You get to decide. Okay. So normal time or normal maximum time that I can get people to work is 9 hours if you're working 5 days per week, or 8 hours if you're working more than 5 days. Okay. I'm going to get to averaging as well. Is that what you can do is remembering, so people get confused here, is that when we're looking at hours of work, the lunch break, or at least let's call it a meal interval, you are required, for anybody below the threshold, to give a meal interval after 5 hours of work of either 60 minutes, or by agreement, we can reduce it to 30 minutes. Okay. Any break of less than 30 minutes cannot be deducted off hours of work. So what would normally happen is, provided I'm allowed to, I don't know, go outside and sit somewhere for 60 minutes, but it is my time, then what I can do is deduct the lunch break from the hours of work. If I'm working 8 to 5, that's 9 hours, plus I get 60 minutes that I can go and do whatever I want. I'm actually only working 8 hours in that day. So when you're calculating hours of work, it's sure that you are deducting the lunch break or meal interval, provided that that meal interval is was 30 minutes or more. If, however, a person is required to work during or be available, so for argument's sake, if you had a receptionist that you did not have somebody who could sit at reception, so the person can have their lunch, they can sit at reception, but they need to be available to, I don't know, answer the phone, then you must pay the person for that time, because it's not their own time. They must be, they have to be available. Okay. Then when we look at a week, okay, a week is not defined Monday to Friday. A week is any 7-day period during which time you will work. So Saturday is considered a normal day, unless Saturday ends up being outside of your normal hours of work. So in other words, if I work 40 hours and those 40 hours, or let's just take 45 hours, and those 45 hours end up being on a Saturday, if it's within the maximum normal time, then I only need to pay at normal time. If, however, Monday to Friday is 45 hours and I work 5 hours on a Saturday, those 5 hours on a Saturday are over 45 hours and therefore overtime must be paid. But you don't pay Saturday as overtime just because it's a Saturday. It is considered a normal day. Okay. The other thing to note is that a day is not considered 8 hours of work. Okay, so very often people will go, well, if you're looking at a day, it must be 8 hours. A day is defined by your starting and ending time. Okay, all right, so if your day is only 4 hours, then that is your day. So when I then apply for 1 day of leave, I'm applying for what is defined as my day. Okay, a day is not a universal thing. It is a 24-hour period, and your day is defined by when you ordinarily start and when you ordinarily finish. Okay, there is an element there that says that if you are serving the public, I can extend your normal hours by 15 minutes per day, but not more than 60 minutes. But that must be for those that are serving the public. In other words, there are people that can just walk in and out. Okay. I'm just going to go to some of the questions quickly, just 1 second. Okay. All right, so Christo's just said, if your contract is 40 hours per week, working more than that is overtime. You do not have to complete 45 hours before overtime starts. Yes, so if your contract of employment is stating that you only ever work a maximum of 40 normal hours a week, then anything over that would be overtime, because overtime is over your normal time. If your normal time is 40 hours a week, then anything over that would then be considered overtime. Okay, I'm just going to go to the other question. All right, so in terms of the over the threshold, it would be considered earnings. Okay, so in my other presentation, which I do on overtime, I actually go into in more detail what would be considered what would be considered remuneration. So you need to look at the definition, but it would be considered anything that you are earning as a result of work. So it wouldn't necessarily be, allowances and stuff like that. So if you're looking at the threshold, and I can send you something afterwards, I haven't specifically included it in here, but it's not your total cost of employment necessarily. It would probably be your normal cash pay, but we would need to see how you've defined that. Serving the public, a cashier, probably public servants such as firemen would probably be as well. The intention of the 15 minutes is that you can work, for argument's sake, in a retail store. You're about to close, and somebody, because you've got opening and closing time, walks in 1 minute before you close. Okay, I think that is the intention. Yes, no, I did answer that one. Okay, alrighty. Okay. So then we look at averaging of hours. Okay, so in terms of averaging of hours, you can, by agreement, I think that was one of the questions that was asked just now, you can, by agreement, average hours over a period of up to 3 months. So you can average over a month. So instead of doing 45 hours a week, you can do 195 hours in a month. And what that really does is that it moves away. So when we're looking at overtime, it moves away from having to pay overtime on a daily basis. So where this becomes useful is if you have, for example, a restaurant, or you have a factory where, things kind of do, in waves. So today I might do 8 hours, tomorrow, because, I don't know, an order comes in, I might do 10 hours. If we're doing overtime on a daily basis and we're not averaging, I won't pay overtime on the 8 hours a day for argument's sake, but I will pay 2 hours of overtime on the next day. But the following day, I may only work, 6 hours. And so when you average hours, what you would in essence do is to say, on average, you will work, for argument's sake, 195 hours. I will then calculate that. And then after 3 months, after a month, after 2 months, whatever suits you, if you work in excess of 195 hours, remembering in month 1, you could maybe work 190 hours, month 2 could be 200 hours, and month 3 could be 195, is at that point you would calculate it all together, divide it by 3, and you would then be able to see did they work more than 195? Just based on my maths, no, they wouldn't have, and so there's no overtime that is due. Okay. All right, I'm going to get to the Sundays and public holidays shortly. All right, so you can do averaging of hours. If you are going to do it, I would suggest that you speak to someone in terms of just having a look and seeing if it works. It works really nicely in organizations where you might have a really busy period and then a bit of a quieter period. Rather than giving people overtime, they have more inverted comma time off, so the hours are different and the low periods, and they could end up working a bit more overtime in the slightly higher periods. Restaurants and that kind of thing, it does work really well. Okay. All right, so we've got another question. So if an employee works on a Sunday or public holiday, must it be paid at double time? Not necessarily. Yes, and averaging can only be done up to a maximum of 3 months. Okay. So if the person is over the threshold, I'm just going to go back to the other slide that I had just now. So if they are over the threshold in terms of public holidays and Sundays, they are excluded if you're over the threshold for increased pay for work on Sundays. But in terms of public holiday, they are not excluded. Okay, so if they're not ordinarily required, they're only excluded from section 18.3. Okay. So remembering difference between senior managerial employee as well as the sorry, I've gone blank. Sorry, there's questions coming through. Sorry, I got confused. So remembering that senior managerial employee is excluded from everything. BCEA threshold, they are excluded from receiving special pay on Sundays, but they are not excluded from everything for public holidays. Okay, for over the threshold. Okay, just going back to my slide. Okay, all right, when we then have a look at overtime, okay, so overtime, there's a couple of things that you need to look at. Is one, overtime may only be worked if there is an agreement to work overtime. Okay, you also need to remember this thing, which a lot of people aren't aware, is I can put in place in my contract, excuse me, I can put in place in my contract that you agree to work overtime. Remembering as a new employee, I'm probably going to agree to it. As a brand new employee, any agreement made to work overtime, either at inception of employment or within the first three months, must be renewed, okay, or reconfirmed after the first year of employment. So when I get to a year, I must now come to you and say to you, are you still prepared to work overtime? And the person can say no. Okay. If there is no agreement to work overtime, I cannot force the employee to work overtime. And any agreement can be done in an addendum. Okay. Alrighty. When we then have a look at overtime, okay. So remembering that Monday to Saturday is normal week. Okay, Sunday is always treated specially, and public holidays are always treated specially. So even if Sunday is an ordinary day of work and or a public holiday was scheduled, you were scheduled to be working, if we're looking at shift patterns, even if it was within the 45 hours or the 40 hours, it must be paid at a special rate if you are, if you fall under the threshold and you're not a senior managerial employee. So in terms of overtime, the maximum number of overtime hours that a person can work in a week is 10 hours. So if we take 45, and that's your normal hours, you can work a maximum of 55 hours per week. Okay, that is you can't agree to more, you can't agree to work 60 hours, 70 hours, whatever. You can only work a maximum of 55, or if your normal hours are 40, you can only work 50 hours, and so it goes. Okay. All right, so if we're going to work normal overtime, you can either, and the payment of overtime is different depending on if it's normal overtime, Sunday overtime, or public holidays. Okay, right, so normal overtime must be paid or given off at a rate of 1.5 for each hour of overtime worked. Okay, so any hour that I work over my normal time, you must either give me, if I'm working, excuse me, if I'm working and I get paid 100 Rand an hour, for every hour of overtime, I must now get 150 Rand. Okay. You can, however, give it to me as time off. So you can pay me 100 Rand and you can give me the equivalent of half an hour off, or you can give me 1.5 hours off, for which you must pay me. Regardless of what you do, you need to make sure that in your policy or whatever, it is agreed that that is how you're going to decide. Yes, time and a half does apply to people who work shifts. Remembering it's about, are you working more than 45 hours? So even if you're working shifts, you're calculating the overtime based on either a monthly basis or you're calculating it weekly or whatever it is. So when you look at the overtime and you go, are these people working? So if it's 45 hours a week, do they work more than 195 hours in a month? If they work more than 195 hours, then you need to pay them the overtime or give it to them as time off. Okay. If, however, it is Sunday, if a person ordinarily works Sunday, so if we're looking at shifts, then that would be classified as an ordinary shift on a Sunday. The person must then get paid for time and a half. If it is not an ordinary day, i.e. I never, ever, ever am required to work on a Sunday, then I must be paid a double. Okay. Now, in terms of Sundays, it works slightly different. So how it would work is that at an absolute minimum, I must receive my normal daily wage for work on a Sunday. So let's assume I'm getting my 100 Rand an hour. I work 8 hours. At the very minimum, I must get 800 Rand. Okay. So if you're going to get people to work on a Sunday, you cannot be paying them, you know, if they work 2 hours, you can't be paying them 400 Rand. They must get 800. So if you're going to make people work on a Sunday, make sure that it's worth your while, because at a minimum, they must be getting 800 Rand. Okay. Unless, of course, they ordinarily work the Sunday, in which they can be paid at time and a half. Now, with Sundays is you can't apply the same rules in terms of paid time off. What you have to do is you would have to pay the normal minimum, so the daily rate, you would have to pay that. Anything over and above that, you could elect to give as time off, but it must be given within a month. Okay. So you could pay the half or the other one as time off. When we look at public holidays, that is paid as double, regardless of whether you ordinarily work public holidays. It's part of your normal shifts. It doesn't matter. It is a special day and it is paid at double. Remembering, unless, of course, you fall within a bargaining council that has different rules. Okay. There is an element there with the shift that falls on a Sunday or public holiday, or if we're looking at Sundays or public holidays, if majority of the shift falls on a normal day, then the entire shift is paid at normal day. If majority of the shift falls on a Sunday or public holiday, the entire shift is then paid at those 2 rates. Okay. Alrighty, I'm just going to have a look at the questions very quickly. Okay, so all right, so if we're looking at commission, so a commission only earner, if we're looking at overtime, so you do need to, so there is an element within the basic conditions that talks about overtime and that kind of thing with commission only earners, and there's a requirement that you would need to average hours. But my suggestion is that what you would need to, because you're getting, people are required to work a certain number of hours to make widgets, for argument's sake. They could do that in an hour, in which case they could end up being less than 24 hours a month. So you need to apply a couple of different logics to go, is the person actually an employee or are they an independent contractor? Do they work more than 24 hours a month? Are they, in fact, an employee? If by virtue of the fact that they are under the threshold, then you would need to start to consider what happens if they're working more than, I don't know, the 8 hours a day. So you have to ask a little bit more in terms of questions and what it is that they're working. So in terms of making widgets, how many hours do they get to do that? So it's a little bit more complicated than a yes or no question. Somebody said, is it 190 or 195 hours a month? So if we're working 45 hours a week, it equates to 195 hours in a month. Okay, so 45 equates to 195. Alrighty, okay, so the paid time on lunchtime and the unpaid lunchtime. So the difference is and this is a sort of easy thing, is going, am I allowed to do with what I want with my lunchtime? If that means that I'm going to go and sit at my desk and eat my lunch there, so be it. Can I go to the shops? Can I go sit outside? Can I do what I want with my lunch break? Yes, you can. In that case, it is unpaid because I don't require you to work during that time. If, however, as a result of my requirement, you need to be, let's call it for lack of a better word, on standby, available for me. So in other words, you can't shoot out to the shops, you can't play games on, I don't know, Facebook or whatever it is that you want to do. You must be at my beck and call, in which case I must now pay you for your lunch. Okay, so that's how it works in terms of the two. Okay. If we then have a look at annual leave, so annual leave is basically calculated, you can have 21 consecutive days per annum, or it is calculated at the 1 day per 17 days work. So if you're a 5-day worker, that equates to 1.25 per month, or if you're hourly paid, it is 1 hour per 17 hours worked. Okay. Now, the easiest way of working this out is you take 3 weeks, i.e. 21 days. You calculate how many days would the person ordinarily work in that time. So assuming the person is working stock standard days. So if I'm working 3 days a week, I would say 3 days times 3 weeks, which is 21 consecutive days. How many days of annual leave am I entitled to? 3 times 3 is 9. I get 9 days per year. If it's 4 days, it's 4 times 3, which is 12. 6 days, and so we go. So that is an easy way of calculating how many days I would work. If the days are not set in stone, you would then need to literally do 1 day per 17 days work. But if you have set days, you could then look at it like that. If you want to work out what the accrual is, if we're doing our 3 times 3, which is 9 days, 9 divided by 12 months will give you what your accrual is, and they accrue every day as they work, so every month at least. Now remember, annual leave is given at the prerogative of the employer, so people can't just phone in and go, well, I'm taking, we'll talk about smoke breaks shortly. People can't just decide that today I'm taking annual leave. The fact that you have it available to you, it must still be taken at a time that is suitable to the employer. It is not just for you to phone in and go, I've decided I'm taking annual leave today, because as the employer, I can say no. Remembering that a day is defined by the person's day. So if I only ever work half day, I don't get 7.5 days of leave. I get 15 days if I'm a 5-day worker, because I get 15 of my days. Okay, a day is not 8 hours. A day is whatever it is that I work. So I'm getting 15 of my days, which just happen to be, for argument's sake, 8 to 12. Okay. There's an element, it was actually based on case law. It was Ludic, where it was decided that leave forfeits 6 months after the year that it becomes due. So it is important, you can't just carry leave over forever and ever and ever. And so you need to put in place a policy, or at least tell people that they must take leave within a certain time. If, however, you can't grant that leave, it would not be fair to forfeit it. But it basically protects the employer from having people who end up with 80, 90, or even 50 days of leave. So there is a requirement for people to take leave. Obviously, it must be applied for. Okay. In terms of long service, can it be paid out? Okay, so just to talk about leave, leave cannot annual leave. So if I'm giving you your standard minimum, which is your 15 days if you're 5 days, that 15 days, even if I accrue it to 80 days, is not allowed to be paid out, excuse me, whilst I'm still employed. So this cashing in of leave is not allowed. And the reason being is that, why do we give people leave? We give them leave so that they can go away and rest or whatever it is. Paying out leave is not allowed. Okay, so you can only pay out leave on termination of employment. You as the employer should be managing the leave appropriately to ensure that people are taking time off. Long service leave is in addition to, so if I give 15 days plus 5, what I do with the additional leave, the 5 days, you can pay that out, you can, I don't know, forfeit it, it doesn't really matter. That is for you because it is over and above the statutory minimum. Long service is also not a statutory requirement. It is a benefit that I have given you as the employer. It is a nice to have. And so I can decide what I want to do with that. I can choose to pay it out, or I can choose to forfeit it. My question would be, though, is if you're giving long service leave and people are not taking it, what is the point of giving them additional days of leave? If they're not going to take it, you are now financially, you have a liability there where people can now use it. If you're going to do long service and nobody's taking the leave, rather decide to give it to them as a bonus for argument's sake. The point of leave is to allow people time off. Okay, I would be very wary of giving people the ability to buy it back and that kind of thing, just because it just sets a bad practice. Okay, all right, so in terms of smoke breaks and tea time, so tea time is something that is given by the organization. It's very often in a factory type environment because I need everybody to stop at the same time. Any break of less than 30 minutes cannot be deducted from hours of work, and so it is a given. Smoke breaks, okay, smoke breaks also, there's nothing in legislation that says I must give you a smoke break, so you decide what you want to do. So you can put in a policy that says if you want to go on a smoke break, you must do it during the break times. There is no additional time off, but it is up to you to decide. There is nothing legislatively that says you have to give anyone a smoke break. Okay, then we're moving on. I'm trying my very level best to try and get this all into an hour. I'm hoping I'm going to do that. All right, so when we then look at sick leave, so sick leave, again, is quite easy to work out, very similarly to the annual leave. It's basically you will take a period of 6 weeks and work out how many days do I work in that time. Okay, for most people, you're working your 5 days. 5 times 6 equals 30. That is my allocation for a 3-year period. So, and remember that with sick leave, you don't accrue it like you would with annual leave. Annual leave, I need to work, and then I get a day or whatever it is into my annual leave bank. Sick leave doesn't work like that. Whatever I would work within a 6-week period, so if I work 3 days a week, 3 times 6 is 18. I get 18 over 3 years, and so you go. Okay. During the first 6 months of employment, however, as a brand new employee, I don't get my full 30 days. If you're a 5-day worker, I get 1 day per 26 days worked. So I must have worked 26 days to have a day of paid sick leave in my sick leave bank. If I haven't worked 26 days, remembering if I only work 2 days a week, my 26 days, because it's not consecutive days, my 26 days probably not come in the first 6 months. If I work 5 days a week, my 26th day of actual work is, around about 6 weeks. So I need to work 6 weeks, okay, in order to get my 1 day in the bank. So if I fall sick prior to the 26 days, I have not got a day. And so although I can be sick, I must, it's unfortunately unpaid. As soon as I get to finish my 6th month of employment, my then full allocation, less any paid days off that I had before, will become due. And so on month 7, I would get 30 days. Excuse me, I get my 30 days. Remembering that, or whatever the equivalent is. So if I work 2 days a week, I would only then get 2 times 6 is 12 days. So I would get 12 days over a 3-year period, and that is how it is worked. Remember that a day is defined by the person's day. So like I said before, if I work half day, I don't get 15 days. I still get 30 days because my half day is actually my day. So if I'm sick for my day. Okay, so each day comes off. Excuse me. Okay, so that's basically how sick leave works. And then we'll get into the proof of incapacity. So with sick leave, you get your full allocation. It doesn't accrue like that unless you're in the first 6 months of employment. Now, proof of incapacity, the way that in proof of incapacity really works is if you can imagine you have a bank, okay, and in my bank, I have my 30 days. Okay, now there are rules at how I unlock. So if I'm sick, how do I unlock that bank to take out 1 day in which I will be paid if I'm sick? Okay. So how it works is that if I'm sick for 1 day, I can just open it and I can take one out, assuming that there is anything in there. Remember, as I take one out, my balance reduces. 2 days, I can take one out. As soon as I've been sick for more than 2 days, than 2 consecutive days, that bank locks, and my other 2 days that I've already got in my pocket go back in there. If I want to take them out, I must produce a medical certificate that covers the full 3 days. Okay. And so I then need to provide a medical certificate in order to unlock that and get paid for my 3 days, at which point it will reduce accordingly. The other time is if I have more than 2 occasions within an 8-week period. So granted, I might get paid in the first instance. Second instance, which is 2 weeks later, I'll get paid for the day, and then next month I'm off again. What I can then do is say to them, going forward, because there's now a pattern developing, I want you to bring a medical certificate. Otherwise, you cannot gain access to that particular day. Okay. So if the person has been there for less than 6 months and they get sick, we don't pay them, but when we check on Sage, they do have a day. So remembering, I don't know how Sage works, remembering if it's less than 6 months, for every 26 days that they work, they accrue 1 day. So Sage may be accruing the 26 days. You just need to check with Sage if it is doing the 1 day per 26 days worked. If it is not doing that and you want to apply the rule, then you would need to check with Sage to apply it correctly. Okay. But if it's showing them that they have a day, then you would need to give them the day. Okay. If a company has a shutdown period for a week, do employees have to take leave during this period? Does the week get deducted from the annual leave? If you're really, really, really nice, then you don't do that. Most organizations, remembering it's my prerogative to decide when people take leave. And so if we close for a week, then I will advise people, excuse me, that we do close for a week. During that week, they would need to, for argument's sake, take 3 days of annual leave, and they must keep 3 days of annual leave for that period. If they don't have it, then it's unpaid. But just because you have a shutdown doesn't mean that you are required to give them additional. They get 15 days of leave. Remembering it says there, it is 21 consecutive days. So for argument's sake, if you're a factory that closes, for argument's sake, from the 15th of December to the 8th of January, the whole factory closes and everybody must be paid their annual leave. They go on leave. I don't give you that time as well as another 15 days. Okay, so you very well, you can take it off, basically. Okay. So in terms of a person who is often sick, I'm not going to be able to cover that today. My suggestion is that when we do the webinar again on managing sick leave, have a look at that, because that goes into, that is a full hour all on its own. Okay, so if an employee takes 2 days of sick leave in the first 6 months, does the 30 days apply in month 7? Or is the 30 the 2 days taken? So if they take their 2 days, remembering I get 30 days in my whole sick leave cycle. In the first 6 months, if I've taken 2 days, it would be 30 minus 2. I don't get 30 and then plus the 2 I've already taken. So you just minus it off, provided that those 2 days were paid sick leave. You can't deduct unpaid sick leave because those 30 days is paid sick leave. So if they've taken 2 days of paid sick leave, you take it out of their sick leave bank. So it's 2, and then you say 30 minus 2, okay, or whatever the balance is. Excuse me. Okay. All right. So remember, so someone's asked about the 8 hours per 5 days a week equates to 30 days of sick leave. Remember, it's not about the 8 hours. If they're working 5 days a week, it's 5 times 6 weeks equals 30 days. Okay, so it's about the number of days that they're working in a week. The only time it would be different is if on day 1 they were working 1 hour, day 2 they were working 8, day 3 they were working something different. But if they were working 5 days a week at 4 hours, they would still be 5 days times by 6 weeks equals 30 days. It's based on the number of days that they would ordinarily work within a 6-week period. Alrighty. Family responsibility. Okay, so this changed a couple of years ago. So family responsibility is no longer for the birth of a child. Sorry. Okay, so basically what would happen is as soon as you've been in full-time employment for longer than 4 months, you are entitled to 3 days of family responsibility leave per annum. Family responsibility is the same as compassionate leave. It used to be called compassionate leave. It's now called family responsibility. So you get 3 days per annum. If your child is sick, remembering a child is anyone under the age of 18, unless that child is financially and dependent on you, so they're unable to care for themselves, or if one of the following people die. It is no longer for the birth of your child. If your child is born, you now take parental leave. Okay, so parental leave, yes, if sick leave is exhausted, you then have unpaid leave and you would deduct it from their salary. Alternatively, you can give them the option of taking it as annual leave. If they have annual leave, you can then do that. Okay. So parental leave, there is maternity leave, okay, which there is case law going on at the moment, which currently maternity leave is for somebody who has birthed a child, and it is 4 months unpaid leave. They can go claim for UIF. You can choose to pay people, but that is an internal policy. Legislation says 4 months of unpaid leave. As I said, there's case law going on where there is, they're looking at saying, why, if I choose as a woman who's birthed a child not to stay for the 4 months, but my husband wishes to do so, why can't he do it? At the moment, it doesn't apply like that, but it may change. Sorry. Then you have parental leave. Now, parental leave, I've specifically not said paternity leave because it doesn't apply to a particular gender. It is 10 consecutive days unpaid leave. Okay. I'll talk into if they need to be in the contract of employment. So where this applies is that if, for argument's sake, we adopt a child, one person can take 10 weeks of unpaid leave, the other person can take 10 consecutive days. Now, it could be that I decide to take 10 consecutive days and my husband takes the 10 weeks, or whereas in a same-sex partnership, the parental leave is not based on gender. Okay, so you can do, if your wife is pregnant, the other person, whoever it is, would end up taking parental leave. If we adopt a child, one person can take the adoption and the other can take parental. And then you've got the commissioning parents leave, which is if you have a surrogate, you can take 10 weeks of unpaid leave, and then the other party could take the 10 days. Remembering it is all unpaid, and you would go and claim from UIF for this leave. All righty. Okay, so since family responsibility no longer applies to the birth of child as a norm, male parents used to take it. Yes, but now they take the parental leave, the 10 consecutive days. All right, so in terms of the contract of employment with parental leave, you do need to have it in your contracts of employment. Department of Labor, when they come and do the audit, specifically look for it. So if you have contracts that are prior to the change, which was actually in, I think it was January 2020, my recommendation is you have an addendum that everybody that has older contracts will sign to say, here's your parental leave now. And going forward, you update your contracts and any new employees will have parental leave. You cannot have a clause that says people are allowed parental leave. They expect the full section to be in there in your contracts. And they do audits on that. Okay. So in terms of the question, yes, again, if a person has having a baby and they happen to be the father, they can get 10 consecutive days. Remembering consecutive, that includes Saturday and Sunday, they get 10 days. It is unpaid and they can go claim for UIF. Currently, I don't believe you can make the claim on new filing, so they would have to go down. They can choose to take 10 days. They can choose to take 1 day. The same as with the maternity leave. A person, excuse me, a person must take 4 weeks before the birth of the child and 6 weeks after, unless the doctor certifies them fit to return before that. It is 4 months that they can choose to take, but they can come back earlier, and that is a negotiation with the employer. All right, I'm just going to get to the last slide, and then I will get to questions for those of you who wish to stay. The final slide here that I'm talking about is notice periods. Okay, so as I mentioned or alluded to in the beginning, you cannot decide that you want to give people 24 hours notice. At the minimum, if a person has been employed for 6 months or less, the minimum notice on both the employee and the employer's side is 1 week. You cannot change it. You cannot say 24 hours or 2 days or whatever. It is 1 week. Okay. If you've been employed for 6 months or more, but less than 1 year, then it is 2 weeks. And 4 weeks is 1 year. I mean, sorry, if you've been employed for one year or more, then it's a minimum 4 weeks. You can increase these notice periods, but you cannot decrease it. And if you do increase it, the same notice period must apply to both the employer and the employee. You cannot have a situation where an employee is required to give you, for argument's sake, 2 months notice, but I, as the employer, only need to give you a month. You can also choose as the employer to pay the notice instead of making an employee work it. That is at the employer's discretion. Excuse me. If, however, an employee fails to give notice, you obviously don't have to pay it, and you can recoup it as well. But I would suggest that you put that in your contract of employment. Okay. And then the last thing just to mention here before I get into some of the other questions, and guys, if you have questions, you can post them in the chat. Upon termination, okay, there's a bit of confusion or people believe a certain thing. You are required to give every employee a certificate of service. And that certificate of service mustn't specify the reason the person has left, but there are things that you need to put in there. This applies even to people who have been dismissed. Okay, it's not a nice to have. You have to give it to people. The other thing that you have to give to people when they leave, regardless of the reason of them leaving, is a UR19. So you must give them a UR19, and you must give them a certificate of service. It is not optional. It is mentioned in the labor relations, the basic conditions. Okay. So guys, I tried to get through most of the stuff. I would recommend that if you've got queries, yes, I will send a copy of the slideshow. If you have specific queries regarding things like managing of leave, sick leave, overtime, then I would suggest, maybe go onto our YouTube, because I've done webinars on those things before, but I do have one regarding overtime and the calculation of overtime. Excuse me. I also have one regarding sick leave. I also have one regarding the different types of leave, which is a whole hour on those particular things. So that kind of brings us to the end of the session today. I'm going to go through some of the questions. Those that need to leave, thank you so much for joining us. We hope to see you again, and we hope this was helpful. And then I'll get to the questions now, but those that wish to leave, though, if you want to stay and we go through some questions, I will also be here as well. Okay, we will send a copy of the slideshow, and this presentation will be up on YouTube probably within the next week. Okay, so I'm going to go through some of the questions. Let me just have a look. Okay, so hang on. Okay, so in the event of a worker being absent without a valid reason for 2 days, can we consider unpaid, or do we need to utilize their annual leave? Okay, so if somebody disappears for 2 days, then it's not annual leave, because annual leave is something that you apply for, and that must be agreed upon. You cannot decide as and when you want to take annual leave. It doesn't work like that. Okay. So if they just disappear, one, there would possibly be disciplinary action, okay, because you can't just disappear. Two, if they come back and they don't have a medical certificate, then it would probably be unpaid leave. If they come back and they say they were sick, then because it's 2 days, you would then have to pay them. But I would also question, though, why didn't they contact you and that kind of thing. So I wouldn't necessarily take it out of their annual leave, because what it does is it gives the impression that if I just don't come to work for 2 days, well, we'll just take it out of my annual leave. And so I then, as the employee, have the ability just to not come to work and say it was annual leave. And so I would manage it slightly differently. Okay. If the employee left without notice, how can this affect the employee? Well, if you have a contractual agreement that says that you must give notice, much like any contractual agreement, you are required to give me notice. So the way that it would affect you is I have the ability, or at least have the right. One, I won't pay you the notice, obviously. But two, I can recoup that notice because you have left, much the same as the reason why I have to give you as my employer notice is to hand things over, assuming I haven't been dismissed, but is to do a handover so that you as the employer can continue operating even though I'm leaving, okay? The same as I need to give you notice as the employee is that I can't just, unless you've obviously done something terribly wrong, but I can't just drop you today because you got to get another job, etc., etc. So if I want to terminate your employment under normal circumstances, I must give you the same notice. So if you don't give me that courtesy, I'm now it's now detrimental to me, and so I could possibly deduct the notice off your annual leave. You know, and if there's money owing, I could try and take it out of that. The challenge comes in is that if people do that, I don't know, unpaid, you're going to have a bit of a struggle. But yes, you could decide to sue them for the money, or you can take it out their annual leave. Okay. Do we also need to give a salary schedule with the certificate of service? Okay, so the salary schedule is not a legal requirement, but it is becoming a necessity just because when people go to Department of Labor, they're being requested for the salary schedule anyway, and so they come back to you asking for it. And so I would always just provide it because at some point they're going to come back and ask you. So yes, I would provide it. Okay. Excuse me. So in terms of the threshold salary, that relates to earnings. Okay, so it's not necessarily total cost of employment, because total cost could include other benefits. So it wouldn't include, for argument's sake, your medical aid. It wouldn't necessarily include stuff like that. So there is a specific things of saying what does it include and what doesn't it include. I can send it afterwards, but you would need to. It's generally normal cash pay, and not generally total cost. But you would need to examine it because I don't know what you've got in your total cost of employment. I don't know what benefits you have, etc., etc. Okay. If a contract has a 3-month notice period, can you hold an employee to this? So notice periods are going to be dependent on how reasonable it is. Okay. So in terms of my question would be, why do you have the notice period of 3 months? Also taking into account how easy is it going to be for that person to go and find another job. So if they were going to go find another job, would that person wait 3 months? You know, and that's really what it's going to be. So if somebody doesn't give you the required notice, the recourse in that space is you would have to sue the person civilly. So you would have to go to court and argue why you have been prejudiced because they didn't give you 3 months. And then it would become a court issue where the court would then ask you all of those questions, because remembering with a notice period, if somebody says, no, I'm not going to work my notice, you can't tie them to the desk and make them work the notice. So they could up and leave. And so your only recourse in that space would be to do it civilly. The question, though, again, would be, is your notice reasonable? And so that is what is going to be tested, is not necessarily the previous precedent, because in that situation, it could be that the previous person was happy. So I would look at the nature of the job. Why did it have to be 3 months? Seniority of the job, a number of different things. Remembering your notice period can also be different based on the person, or not the person, the position. Okay, so that would be my question, is asking those things to go, is it reasonable? Okay, if we deduct notice from annual leave, do they sign an acknowledgement of debt first? My No, because, well, okay, so they're probably not going to sign a notice of acknowledgement or an acknowledgement of debt, purely because they've left. So they're probably not going to acknowledge the debt. What I would do is, if they have decided not to work their notice, I would firstly remind them of their contractual agreement, which says that they need to work XYZ notice. I would then urge them to work the notice. Then if I say if they're not going to work the notice, we then reserve the right to claim the money back. Okay, and that could be via their annual leave, which we'll do now, but we are reserving the right to take further action, which could mean taking civil action. Sometimes the person will say, oh wait, I didn't know that, and then work their notice. Alternatively, you've just reserved your right, and then you can then decide what you want to do with that. Okay. Okay, so I'm just having a look. As a school, our standard notice is a term. Okay, so that is, so within schools, obviously, that is a general norm, but in schools understand that that is a general norm, and so they are happy to wait a term. So within the school environment, it would be justified to give a term's notice, because other schools are also expecting that people are going to be giving that notice. So there, I would say it probably is a little bit different. Okay. So I think, hold on, let me just check the Q&As if there's anything else. So in terms of the UR19, yes, you are required to give them to the employee themselves. You can send through to Department of Labour. I would give it to the employee, just because you've given them everything, and then it's just easier. Okay. Alrighty. Okay, last couple of questions. What happens if you have fixed term contracts? Okay, so my question would be is, why are you rolling over a fixed term contract? And that would be my question. So if you have a fixed term contract for a year, then that would be, in essence, it would be 10 days. I would be hesitant about asking why you're rolling it over. If you do need to roll it over and there's a justifiable reason, then they would get the equivalent of, remembering they would get 10 days, but they would get their full 10 days. Okay. All right. So in terms of annual leave and sick leave, if they've exhausted it, it's really the employee's prerogative if they want to take their annual leave. But I mean, it's either unpaid, or they can have the option of taking it as annual leave, but you can decide not to, especially if you've got shut down and they need to save it. All right. Then we've got a question regarding standby. Okay, so. All right, so in terms of standby, there is nothing in legislation that tells you what standby is and how much you need to pay it. It is generally decided by the organization, and the definition of standby is also decided by the organization. There's nothing in the basic conditions that talks about standby. They do talk about night shift, but they don't talk about standby, and so that would be an internal policy that you guys would decide. Okay. All right, what happens if someone is called in on a day off? That would be overtime, because that's a day they're not supposed to work. All righty. Okay, I think that I've answered all the questions, hopefully so. If anybody has any more questions, please feel free to email. And then, I can help you as best as I can. I do hope everybody enjoyed the session, and I hope to see you guys soon. Okay. Thanks, everyone.